You're on it, remember?
Yeah.
You got your resolution.
Yeah. Hold on. What else we got left?
Richard. Got Richard in your resolution.
Is Richard here? Huh? Okay. Where's Senator? We got Senate concurrent resolution. You handling Richard's? Come on, Judge. I'm sorry. We didn't know. I need to see Brown's. You have a copy of it?
Thank you, Mr. Chairman, members. Bob Morrison, Louisiana District Judges Association. I'm here this morning relative to House Bill 784. Before getting into this, let me just give you a little background for those of you who are not in the court system. All of the official court proceedings are reported by a court reporter by one of various means, either stenographic, some mass reporters, and that sort of thing. Most courts run a backup system to that, and most courts at this point it's a digital recording that's done on a compact disc type deal. This is a backup for the court reporter. The official transcription is made through the means that court reporter uses. Recently there was an issue brought up where a person tried to access this backup compact disc, and therefore we brought this bill. The reason for the bill is there's several. Number one, there has to be an official transcription of the court proceeding, and that's very important for the integrity of the court record. Secondly, typically these backup recording systems are just switched on in the morning and switched off in the evening, and there can be some things that get on that recording that are not part of the official record. For instance, during a period of recess, an attorney may be consulting with his client over the facts of their case, and the microphone picks it up and it goes onto that disc, and that obviously is attorney-client kind of mess. Also, I suppose an attorney and another attorney during a period of recess could say the judge was an idiot. I wouldn't want that to be on the record either. So there are other instances. For instance, if a judge calls the attorneys to sidebar, and perhaps I think somebody's getting out of line and there's a jury there, and I don't want to admonish them in front of the jury, but just say, look, you need to calm down, straighten out. I don't really want that on the record. So all this is doing is saying that this backup, which the court reporter uses, is a fail-safe system. If there's some glitch in her recording system in preparing the transcript, just clarifies that this is not a public record, and I'll be happy to answer any questions.
All right, Senator Murray has a question.
Judge, my only question is I want to make sure this doesn't do anything with this court reporter bills we had from a year or so ago where we had this big fight over how they...
Senator Murray, I'm actually kind of interested that I don't have a backup behind me of hundreds of court reporters who are saying they don't want to lose the ability to produce these transcripts, as part of their business. But no, I have talked to their association, and they are in favor of that.
That was a big fight.
Yes, sir.
And I'd like to move favorable at the appropriate time, Mr. Chairman.
Senator Raza?
Judge, when you walk in these rooms, the assumption is that the mic is live also.
So, yeah.
I mean, a lot of times it is live. So those are public records, and they're there for infinity, basically. I think 15 years, but they're there. Are these what you're talking about now and protecting? Is it subpoenable or not? Or
well, that's the issue that we're trying to avoid here. And Senator Rice, I think the difference is that we have to have a record, an official record in a court proceeding that is what goes up on appeal, and that's what's being prepared by the court reporter. This is simply a backup recording system that they use. For instance, sometimes there are issues that you have two witnesses speaking over each other, and it's difficult to decipher, and that the court reporter may use it for that purpose.
I guess to get to the heart of my question, though, is let's say somebody made a threat, maybe a death threat, verbally, and it was hearsay back and forth, and there was only two people in the room, and they're saying they threatened me. No, I didn't. Yes, they did. No, I didn't. And then you say, well, it's on the record. It's recorded.
Well, if it's on the record, it should be on the record as far as what happened with the court reporter's transcription.
If it was on a hot mic that we're talking about, like protecting now, though, would that be admissible or would it be subpoenable at any point in time?
If it was part of the proceeding, and there's some other exceptions too, let me point out, and that is in the bill there are certain organizations, for instance, the Judiciary Commission, if a judge has gotten out of line, and it may be a demeanor issue where a transcript wouldn't pick up that I was screaming at an attorney, for instance, they have the ability to get the actual backup recording of that. Same thing with attorneys with the disciplinary proceeding and everything like that. But the record itself, as far as the court record, is what's produced by the court reporter. And, you don't want a deviation from that, and you don't want, some people just to be able to...
I think you want a clear break from the clear court hearing, but then the other part I'm talking about, there would still be a way to obtain that if there was some kind of threat made or something that was...
I would assume that law enforcement obviously could get to that, yes, sir.
Okay, that'd be my only concern, like in a domestic issue where somebody might be, in this for instance, might threaten somebody and...
Right.
Where there be might death threat occur and something of that nature.
Well, and I think this is outside the realm probably of what would constitute actually a public record as far as some type of other transcription. For instance, law enforcement now has the ability to go through the process to get your emails or cell phone records and that kind of thing. And I hadn't even thought about that in the context of this, since we're talking public
that's
record.
my only question. I trust your judgment, but that was my question.
Yes, sir. Thank you.
Senator Murray moves that we report House Bill 784 favorable. Hearing no objection, it's reported favorable. Good job,
Thank you, Mr.
Judge.
Chairman. Members, thank you. I don't get in this committee very often. I appreciate the
Thank you.
opportunity.
Maybe you ought to come back.
I'm scared.
I have